Now, SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details.
Now, as we therefore understood this, the political parties have come and said we have received so much from so and so. The details which we will give will make the database complete so that we have who purchased, when he purchased, and when they have got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First, yes. Tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store it?
Silos. Your Lordship noticed that in the next order. So the data is maintained in 2 silos.
You store it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first silo is the bond number.
Bond number is only on the bond.
And the third is the redemption.
Well, bond number is only on the bond, and it cannot be read except through under a UV light. That was only done, like authentication, because it was a bearer bond. That's what was sought to be.
What is the purpose of the alpha? And second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
it security feature entirely?
In the audit trail, you also
no. Audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question: yes. How does the redeeming branch?
Yes.
How does the redeeming branch?
Yes.
Match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the alphanumeric.
Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
Fourth, what is the information that you see when you scan the alphanumeric?
You see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is not in your Lordship's order. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in it. We next get to see the bond when somebody comes and says,
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
But even in the final judgment,
say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Your Lordships,
all details.
That's why we came to
Mr. Salve will clarify to put it beyond any.
No problem at all.
We will say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners who say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
And we'll do it, Malad. There's no problem. Just that this constant, Malad, the media constant beating down and the petitioners giving public interviews saying we will take the State Bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the faith of this. Your Lordships granted an interim order saying keep records. It wasn't at that time, my lord, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your Lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove vulnerability, matters your Lordships will.
This was always the idea behind the interim order was, in case a writ petition is allowed, then
Yes.
data should come out, and that's what exactly is required. Nothing more.
I must say so, my lord, as out of whatever, my lord, the Chief Justice is saying, your Lordship will clarify. We will give every bit of information, relevant, not relevant. We'll give every bit of information which we have, so that, my lord, there should be no feeling that SBI is interested in somehow holding something back. I only want, my lord, to share one thing. My lord, your Lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing that Lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know. Just absolutely, and my lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so and so, investigate so and so. That is, I don't think, the purpose of your Lordship's judgment. That was not what it was meant for. And your Lordship will see whatever safeguards need to be put in place.
We direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date although.
Could we have one more day on Thursday?
Stating, yes, that's certainly 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
To the Election Commission,
in terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.